for inclusion in the list, Lordship.
Motion.
Inclusion in the list.
Motion or hearing?
Hearing, Lordship.
Please,
My Lord,
please.
the matter is not in the list. The urgency is the interim order.
But so many motions are there. Hearing.
My Lord was himself in this matter, Lordship. Nakulnath. Nakulnath, if your Lordship recalls.
To hear it.
My Lord, it has been, my Lord is taking up group 4 matters, Lordship.
I will not be able to hear it if I was there in that matter.
Yes, your Lordship.
Case, then I'll have to release it.
Yes, your Lordship. Then kindly, my Lord, keep it as to be mentioned tomorrow. To be mentioned, Lordship. Gratefully, Lord.
My Lord, I am praying for mention, my Lord.
My Lord, let the physical mentioning be over then. Yes.
My Lord, may I have an indulgence to mention this matter. This matter was in the monthly list of September, but not in November.
Lord, of course, I am mentioning very urgent hearing matters. This was specially fixed for Chatterjee, but due to change of determination, even in the last week. Well, this is a denial of admission on the ground of sex.
Mr. Sanyal, only thing is that so many motions are there. I do not know how I'll be able
to add it so that we can try our.
I have said everybody to mention it next week. Motion matters next week. I mean, hearing matters next week. I'll take it up. Send anybody. I'll take it up. Same. Next week.
May I have a lordship, my lord, because the urgent matter for hearing.
Hearing matters I have just now said. Please don't mention this week. Don't mention hearing matters this week.
The hearing matter, but it was heard substantially by your lordship, and it was fixed after some.
My lord, this is for inclusion of a motion state matter.
Motion, please give.
My lord, one more issue, my lord. This is a application of CAN for modification of order passed by Justice Raja Basu Chaudhary. My lord, it will be mentioned over here.
Modification applications, if the Honorable Judge is there.
My lord, may I be permitted to mention one matter for inclusion, my lord? This is the hearing matter group 2, my lord.
Hearing matter.
There is extreme.
Not now. I've just now said. I've just now refused 3-4 people. Please.
Lord, I am praying for inclusion of the matter in the monthly list.
Motion.
Yes, madam.
Motions, please give.
My lord, in this requisition, my lord, Honorable Division Bench, my lord.
I've never heard it. I've only said that I may hear it. I remember it. I never heard. So still, please wait. I have not taken any hearing matter this week. I will not take mentioning for hearing matters, making an exception. Even then, it's a hearing matter. Please mention next week. Next week is 15. Then, please mention. Try your luck.
My Lord, may I have your lordship's kind leave to mention one matter. It's a hearing matter. There's some urgent.
Hearing matter I have said not this week means not this week.
Not this week. But next week, may I mention this matter?
Right.
I have some urgency.
See how I proceed.
Yes, ma'am. I have some urgency, my lord. That is why I have come.
That everybody has.
Yes. No, he's retiring on January.
I can't help it because it is only this week that I have got this determination. See the number of motions. I'll have to dispose of those motions.
I understand.
Hearing matters have waited for so long now. Yes. Suddenly, if urgency is created,
my lord, it is because, my lord, kindly allow me next week.
The matter was not waited for so long. We have no other alternative. We have mentioned on several occasions with both several honorable judges. Matter appearing in the list, matter could not be taken up. That's the whole problem.
Well,
let us see, sir. I'll organize my list one.
His pension papers, if could not be prepared for January, he is retiring, my lord. A teacher has been demoted.
Very well, I shall see. Arrange my list.
Yes. Lord, kindly allow on the next week, my lord. I'll come back. Great.
My lord, I am praying for mention, my lord. My lord, I am praying for mention, my lord.
It's a motion matter or a hearing matter? Please give this. Motion, please give this. No, one cannot. আজকে তো unauthorized day রই unauthorized matters first. There are 2 matters, then I'll.
My lord, I am praying for mention, my lord, on matter, my lord.
Oh, keep mentioning. Yes, what
my lord, contempt matter, my lord. Contempt matter, my lord. Your lordship, please to pass an order, direction upon the state secretary, STA, my lord, but not comply the order, my lord.
That I
All
filed
right,
a contempt
mention
application, my lord.
who is there? Nobody is there to hand over the slip.
My lord, during this day, I may hand over the slip, my lord. During this.
Very well.
Grateful, your lords.
But this is my application. I am for the petition.
On the
আমাদের
side.
affidavit in reply টা file হয়েছে? But this is the reply I am. I don't know whether they have filed the
Affidavit
opposition.
is not there on record also.
Very well. Next day I shall file. But the Mr. Asen, Union of India. Union of India has no role to play.
Serve a notice. I'll take it up next Thursday because nobody is there.
On over telephone because I mentioned before lordship the day your lordship takes up this jurisdiction first day. Next day we arrange for the file before the learned court officer sent the requisition. Then the court was locked. Then we informed the register. Then register opened the court, and thereafter the file was brought in. So we could not get any time. After the file is brought in, we have informed him over telephone that the matter likely to taken up tomorrow. But on Friday, on Thursday, this is the thing. But
Very well.
they did not respond. Now, but the only problem, very well, next day I shall see it.
None appears for the respondents. Full stop. Mr. Chatterjee, learned advocate appearing for the petitioner, submits that the learned advocate for the respondent has been telephonically communicated about the mentioning of the matter before this court. Isn't it? Mr. Chatterjee, you informed them telephonically.
I cannot, because the senior counsel, I cannot. My clerk and junior, both of them informed.
Because on the first occasion also, when the matter was taken up before the earlier bench.
Well, I am told, Mr. That is coming.
Sir,
he is engaged in court number 1.
I'm making it not today then. Unnecessarily, I'm passing this order.
Can
Let it appear
short
next week.
Passover, he is coming.
Short Passover, if I go on these matters, difficult to come back again. And it appears, this also appears to be a hearing matter.
This is hearing matter.
Yes.
No doubt
I
hearing
have not
matter.
taken hearing matter this week. I don't want to make an exception.
This is no doubt here because all affidavits are complete, although there is no interim order, but in view of urgency.
None appears for the respondent. Full stop.
197.
No affidavit in opposition also has been filed.
No, affidavit is served on me. I have given reply to them, but it is not in record because matter did not appear.
Mr. Chatterjee, learned senior advocate appearing for the petitioner. Affidavit in opposition has already been served.
I am filing affidavit in opposition.
This is reply. I have served them.
Affidavit in opposition filed on behalf of the respondents is taken on record. Affidavit in opposition filed on behalf of the respondents is taken on record. Full stop. Affidavit in reply thereto filed by the petitioner is also taken on record. Full stop. List this matter for hearing on when do I keep it?
Next Thursday on 13th. Today is 6th. Because
13th.
Because my problem is this: the property has been.
None appears for the respondent. Thakbena, you give your name since you are appearing.
The property has been taken possession in the month of July without informing anything to me.
No. দিয়ে দিয়েছে affidavit file করে দিয়েছে
Naturally motionের পরেই থাকবে
November 13.
Now next Thursday after the motion this will appear in the unauthorized group. Yes.
না ওই unauthorized এর গ্রুপে unauthorized hearing in respect of unauthorized করে আলাদা একটা করে দেবে
unauthorized group after motion it will appear.
লিখে নিন none appears for the petitioner. Full stop. No accommodation is prayed for. Full stop. List this matter once again on November 13. 2025 under the same heading. হ্যাঁ ওই তো যেখানে ছিল unauthorized ওখানেই তো থাকবে।
May I please, my lords?
I'm
for the petitioner, my lords.
I'm for Union of India. I'm not answering response. GST matter. I'm for this.
My lords, this matter lies, my lords, I know there's a bulky compilation, my lords. Matter lies in a very, very narrow compass, and my lords, it's largely covered, my lords. Lords, I am aggrieved by an order dated 31st August 2024, my lords, passed by respondent number 2, wherein GST demands have been raised for the period prior to liquidation under the Insolvency and Bankruptcy Code 2016, my lords. Now, my lords, the petitioner was acquired by an entity called Jindal Stainless Limited under Insolvency and Bankruptcy Code, via an order dated 11th December 2023, my lords. Now, NCLT in its order dated 11th December 2023, my lords, has clearly indicated that any past liabilities prior to the acquisition date shall stand extinguished, my lords. And my lords is well aware that IBC overrides any of the law for that time being in force. And pursuant thereto, my lords, a sale certificate was issued by the official liquidator, and the liquidator also has recorded a finding to that effect, my lords. My lords, may kindly take
the sale was on as is where is basis?
As is where is basis on a going concern basis, my lords. And my lords, applying the clean slate principle, which is the backbone of the IBC, my lords, the several high...
The sale is on as is where is basis.
Yes.
Then the liabilities will also be sold.
No, my lords.
Yes.
When it is on a going concern basis, in case of an IBC, my lords,
even in case of IBC, if it is a sale on a going concern basis,
yes, my lords.
Then and if it is on as is where is basis,
yes, my lords.
Then in that case liabilities are sold.
My lords, but the order of the NCLT as well as a sale certificate of liquidator, which clearly envisages and talks about this aspect, says that all past liabilities shall be extinguished, because, my lords,
the order of the NCLT, if it says so,
yes,
then
it says that, my lords, and that order
sale is on as is.
no, it says that, and it says that, and this order has attained finality. It has not been challenged, my lords. Number one, and number two, my lords, this sale on as is where is basis has to be distinguished on a where it pertains to liquidation of assets on a standalone basis, my lords. Because again, my lords, here sale on going concern basis, my lords, where it is involved, again, the basic principle is to revive the corporate debtor and to ensure that the new buyer is able to run the business without any past liabilities, my lords. And this particular ratio, my lords, has been laid down in various high courts, my lords, in the context of liquidation on a going concern basis, exactly identical to the facts of my case. And my lords, one interesting fact is that this order pertains to the period 2019-20, my lords. For the period 2017-18, the department themselves have accepted this proposition and has dropped the demand. In my very own case, they accept Ghanshyam Mishra, they accept Kashfi Power by this honorable, a coordinate bench of this honorable High Court, and they refer to the NCLT order, and they say that yes, it can't be sustained. So, my lords, in that sense,
if you yourself have dropped the proceeding in respect of an earlier year, then how can you on the same basis impose a demand again? In case of 17-18 or 16-17? 17-18, you have dropped it on the basis of the sale being done on the basis of a going concern, as a going concern. Then how can you again raise a demand in respect of a subsequent year?
What happened?
And more important than that, if the NCLT has said in the order by which the sale was confirmed that the past liabilities would get extinguished, then in that case the order governs.
My lord, I have to take instruction in that regard because today I don't have the instruction because, my lord, it appears from the order itself that
where is that NCLT order?
My lord, NCLT order is at page 116, my lord. The relevant portion is at page 122. Para 21, madam. Para 21, is my lord there?
Yes, yes.
Para 21, with regard to the waivers, with respect to the waivers with regard to extinguishment of claims which arose prior to initiation of CRP and which have not been claimed are granted in terms of Ghanshyam Mishra and Sons and versus Edelweiss Asset Reconstruction Company where the Honorable Apex Court has held that.
Yes, yes, I've got it, yes. You see paragraph 23, 24.
Yes, my lord, I was
at page 123.
Yes.
The only entitlement of yours is in terms of section 53, waterfall. Beyond that, nothing. Because this order binds you. You please take instruction, come back, then Monday I'm keeping it.
Already instead of Monday, I will kindly keep it in word test. Take time today.
Why?
Today's first time, I have to take instruction of the department. Department takes sometimes the lordship knows.
But in this matter, what instruction will the department give?
No matter regarding the order passed, my question is that there are
the order is binding. You cannot
Yes,
dispute
that
the
is
order.
binding.
You say that NCLT did
appears
not
from the
pass this
earlier
order.
that the department had dropped the proceedings in respect of the earlier proceedings.
He is supplying that copy.
My lords, kindly takes paragraph 7.6 onwards, my lords.
Which one?
The order, my lords, which has been passed by Kolkata North Commissionerate, my lords.
So you have given two
My lords,
orders.
maybe, my apologies, my lords. It's the same order. My lords, 1718 takes paragraph, my lords, kindly takes paragraph 7.6, my lords. Onwards, my lords.
Seven 7.9 is the relevant paragraph, my lord. If you kindly stick up
7.6 onwards, they have discussed Ghanshyam Mishra, Kashvi Power. Then they refer to 32A of IBC code.
Yes, 7.9.
7.9, they drop the proceeding, my lords.
So nothing remains. Please take instruction on this and come back, because with this facts are absolutely against you.
I appreciate
because you have referred to the resolution plan.
Yes,
You have referred to the order. Although it's not a case of resolution, it's a case of liquidation.
It's a case of liquidation on going concern basis, my lord.
So this reference to resolution plan appears to be faulty.
Yes,
there is no resolution plan. It should be NCLT's order.
It is NCLT's order. Yes.
Well, it takes about word test, my lord. Instead of Monday,
Order dated 11/12/2023. It is this order only.
Yes, my lords. 11/12/2023, my lords.
So this order has been relied on.
No, that is there. But the order passed on 31st August, I think, 2024.
It also relates to which period?
This relates to 1718. This order relates to 1920.
1920.
Same.
Maybe same, my lord. I have to take instruction. Why the department has passed this order, knowing fully well that the matter is affirmed by the Supreme Court, saying everything there. Well, kindly take some, instead of Monday, take some word test, my lord.
Very well.
My lords, may I kindly indicate something, my lords? On last occasion also this matter was taken up and I had supplied the same copies of the orders in the compilation, and verbally directions was given by your lordship's Justice Rajashi Bhardwaj for seeking instruction. I have been at pains for getting this matter listed, my lords. May kindly fix it at the top of the board.
It will be taken up. Nearly. The petitioner assails an order dated. What is the date of the order?
31st August 2024, man.
Page
43.
An order dated August 31, 2024, passed by. This is an appellate order.
Joint Commissioner.
This is an appellate order or
this is an adjudication order,
This is adjudication order.
An adjudication order could be an adjudication order dated such and such. This is under section 73 or 74?
74, my lord.
73,
sir.
73?
73.
Passed under, where do I get that?
My lord, may kindly take page number 51, para 5.1a, my lord.
51, para 5.a, 1a.
My lord, the last line which appears recoverable under section 73 of the said act.
Under section 73. Passed under section 73 of the CGST Act, 2017. Inter alia on the ground that the petitioner company was sold. The name of the company remained the same.
Name of the company remains the same.
That the petitioner company was sold as a going concern in liquidation process initiated upon in liquidation, and that sale was confirmed by the NCLT by an order dated December 11, 2023, holding that
Well, only difference is that my London friend relying upon the order of the administrative authority is 17 January 2025, and the order was passed on 31st August 2024.
no, but the period is prior to the company being sold in liquidation, or the period is after the company being sold.
My lords, that is 1718. This is 1920. The order is 23, my lords.
The sale was confirmed in 2023.
Absolutely.
So it falls prior to the period of the company being sold in liquidation.
Yes.
The effect is the same. That is the problem. They have gone by the order of NCLT. I think they have written wrong date.
They have written a wrong date. Yes, my lords. They have written 7/3/2000, which was the initiation of CRP.
Yes.
It should be ideally 11th of December 2023, my lords.
And what is this order of 2024 which has been referred to here? Order dated 13/9/2024. In the order that you handed up to court.
Yes, my lord.
Paragraph 7.5.
That was
My lords, I think again it should be 11th of December. This was the final your order passed by the NCLT in this matter.
No, but they are referring to another order of 13 September 2020.
This was finally, I mean, approving the entire process, my lords. I'll carry this order, my lords, on the next.
You bring that order.
Yes, my lords. I'll carry this order.
No, एकदम शेष है. No. The judgments of Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited, page 122. Within brackets 2021 9 SCC 657 and Lalit Kumar Jain versus Union of India within brackets 2021 9 SCC 321 would apply to the petitioner's case of it being sold as a going concern, full stop. It is submitted that in view of the aforesaid observation of the NCLT, all past liabilities of the petitioner within brackets prior to the sale in liquidation, bracket closed, would get extinguished. Full stop. Paragraph. Mr. Bhattacharya, learned advocate, appearing for the respondent GST authorities. GST authorities takes time to take instructions. Full stop. Paragraph. List this matter for further consideration on August 13. Sorry, November 13.
My lord, keeping is that to be mentioned.
No, it will appear as it is appearing.
My lord, my lords.
November 13, because it's a 2024 matter, so it will get precedence.
My lords. Because I've been at pains, I've mentioned it at least on 15 occasions, my lords.
No, it appeared on one mentioning only, I think.
This time, my lords, yes, my lords. I'm highly, deeply obliged, my lords.
2025.
My lords indicated Wednesday or
Wednesday.
So Wednesday.
13th is Wednesday.
12th, my lords.
Oh, 12th. Okay, 12th.
Much of.
Well, instead of kindly keep it 13th.
13th will be unauthorized occupants day matters also, because now everybody is pressing for hearing matter also. I'll have to organize it. One day kindly press them, because it's their record. Nothing more is to be found out. Instructions only on legal aspect. Help the court also to move faster.
No, that is not the case. Is at 12th. I think, my lord, one matter is pending. My lord, parted in before discernment. If I can, my lord.
11th.
11th is too early, then, my lord.
Why too early? You have one day here, one day next week. Saturday, Sunday, holiday excluding.
Very well, keep it 12th. Let it
12th, yes.
Much
if
of.
Mr. Bhonjo will be there. He is competent enough.
He's more than good enough. My lords.
Both we are engaged in that.
No, so one of you be there, one of you will be.
Much of.
My lord, in item number 2, my lord, I am for the petitioner.
Mr. Chakravarti, in last day's matters where I remanded matters on the ground of condonation of delay, I found in some orders it has missed to be gone down that the order impugned is set aside. So that I have included, because remand means So I thought I should put you on notice. Because remand in any case, just to put the record straight, I have included that paragraph. Yes, sir.
My lord. My lord, I am for the petitioner. This is a very short matter, my lord. I am a manufacturer of wooden furnitures, my lord, and this is a mall setup, and I have been filing my GST. But problem was, due to some financial hardship, I asked my manager to file the returns, and there was an inadvertent mistake, my lord, which is, my lord, at page 14, against which I also gave them a letter for rectification. But surprisingly, I received 2 demand notices demanding a huge exorbitant amount of to be paid, and against that, my lord, I am before
But
your
this
lordship.
is an appealable order.
My lord, kindly sees the last order, which is at page 21.
Yes, but this is an appealable order under section 107. You have to have approached the appellate authority. And 2024 order, you are telling February 2024. It's almost 2 years now.
My lord, I respectfully submit before your lordship, my lord, audio alteram partem and nemo judex in causasu are 2 basic fundamental pillars of natural justice, my lord. I have been not given an opportunity to be heard, and my lord, the order has been passed, my lord.
Where is that case made out in the writ? There is a notice at page 18.
Yes, my lord.
Which is dated February 9, 2023, which calls upon you to submit your explanation, I think.
Yes, my lord. Accordingly, a letter has been sent, which is at page 13, my lord, P1.
Page 13 cannot be an answer to page 18, because page 18 is post page 13.
My lord, after
Not annex the show cause notice. There is nothing on record, my lord.
Where is the case made out in the writ petition?
my lord, to the demand notice at page 18, after that I am told by my client that he has personally visited.
Told will not do. Where is the case made out in the writ petition? You go before the appellate authority.
My lord, kindly takes up averment number 9.
Yes. Nine is not on natural justice.
And my lord, 8.
Eight is also not on natural justice.
My lord, I am only before your lordship if
You have to give me some material, sir. I cannot out of thin air conjure something which is not there. You have your avenue, you know what to do. It can't be helped.
my lord, one opportunity, my lord, if I can
Opportunity of what?
to file additional documents.
Before this court?
Yes, my lord.
For what? Your case is not there in the writ petition that you are not heard. There is a notice which is dated February 9, 2023, which calls upon you to make payment, says that that if you do not do it, legal action will be taken. Even then you don't, wake up from slumber. You have only woken up almost 2 years after 12/2/2024.
My lord, because the notice was received at a later stage. The order was passed.
Which notice was received?
The order was passed, my lord, at
When did you
P5,
receive? When did you
page
receive?
19. P5.
The
The date was
when did you receive this notice?
this was received at a much later stage in 23, 24.
And you filed your writ petition in August 25.
My lord, they are laymen. They came before.
This is too much.
This is within limitation. Only direction I am harping upon
Very
before your
difficult
lordship
in just
is
cases.
to give, my lord,
In
is to
just
give a
cases,
fair
I
chance
pass
of
orders, but this I don't find any reason. How
fair
can I-
opportunity of hearing. Only that much.
Opportunity of hearing, you should show that you have not made out a case in the writ petition, sir. There is another side also.
Yes, my lord, it's my pleading. My lord, it's my humble submission before your lordship.
Where is your pleading? You don't have a pleading, you don't have documents. How can I pass an order?
My lord, abutment 10.
Huh?
10. And my lord, ground 3.
Violation of natural justice merely because you have written, use the expression, therefore I shall entertain this. Is this the kind of pleading that that you do?
My lord, it has been drafted. I can understand, but
You cannot. If you can understand, then you should not make this submission.
then my lord, kindly allow me to amend this.
Amend what? Amend your pleadings to
My lord.
incorporate grounds.
No, ground is there already, my
No,
lord.
sir. You
Ground
have
number
your
3, my
remedy
lord.
For the appellate authority.
My lord, may I come
The
up with an
petitioner
instruction, my lord?
Assails an order dated February 12, 2024, passed by an adjudication order dated February 12, 2024, passed under Section 73 of the WBGST Act, 2017, whereby the petitioner has been found liable in a sum of 82,78,093. The liability, total liability is this, page 21.
Yes, ma'am. For 1780 months.
On account of tax, interest and penalty for the tax period April 2018 to March 2019. Please see page 21. This is the total, na? Total is 82,78,093. Full stop. Paragraph. The writ petition has been filed on August 20, 2025. That is more than 1.5 years after the issuance of the order impugned. Full stop. Paragraph. Although no period of limitation is prescribed for filing a writ petition, comma, yet it is well settled that writ petitions should be filed before this court, before writ petitions and petitions under Article 220, under Article 226 should be filed at utmost expedition and delay. Occasion, comma, if any, should be properly explained. Full stop. Paragraph. It is settled law that if the petitioner has disabled himself of availing the statutory remedy by his own delayed approach, full stop, comma, the same cannot be urged as a ground to entertain a writ petition, within brackets, A.V. Venkateswaran versus Subraj, 19 AIR 1961 Supreme Court 1605. Bracket closed. Full stop. Paragraph. Furthermore, no ground has been made out warranting interference under the highly prerogative extraordinary writ jurisdiction of this court under Article 226, bypassing the statutory appellate remedy available to the petitioner under Section 107 of the WBGST Act, 2017. Full stop. Paragraph. In view of the reasons aforesaid, comma, this court is not minded to exercise its discretion in favor of entertaining the writ petition. Full stop. The writ petition is therefore not entertained. Full stop. This order shall, however, not prevent the petitioner from approaching the appellate authority in accordance with law.
My lord, one inadvertent request, my lord. Kindly records my submission that on 2021, I have informed by a letter that there had been some mistake on my part. They could have rectified that and given me a chance of rectification.
The petitioner,
It is at page 13, my lord.
The petitioner submits that the order impugned has been passed without taking into consideration a letter dated March 11, 2021, issued by the petitioner to the GST officer, Group B, whereby the petitioner had brought to the notice of the said officer that there was an inadvertent mistake in filling up of form GSTR 3B of 2018. That's it.
My lord, and one another innocuous period, if I may be allowed to appeal before the appropriate.
I have said that you have liberty in accordance with law.
Without limitation being
No.
applied.
That
Or only
file
that
an
much.
application for limitation, the appellate authority
Only that much, my lord.
What is the reason I'll condone limitation? Why? If you had approached at least within some reasonable period, I would have done that.
But my lord, there has been the
is not entertained. Declare it WPA 19429 of 2025 Stands dismissed. There shall be no order as to costs.
At least if the limitation be considered, my lord. And
There's
they
no
may
ground
they may hear it, my lord.
Sir, please don't waste unnecessary time.
Only that much, my lord. A litigant is coming. My lord, the affidavit of
Come within
service.
time. Affidavit of service filed today, we get to this.
My lord, the litigant has approached, we received the order at a much belated period.
Should I recall the liberty granted?
My lord,
Then please don't do that.
I am grateful, my lord.
But this is my application. But in this writ petition, the petitioner is challenging a show cause notice dated June 24, 2025, which your lordship will find at page 326. I think volume 3, subject to your lordship's kind consideration.
Hey, Didi. কেটে দিন নাই কেটে দিন দিন আমাকে দিন আমি Volume 3.
Volume 3. Now, if your lordship kindly takes page 326.
Page 326.
326. My lord will kindly take, my lord, paragraph 1I and II. Your lordship will find the show cause pertains to the financial years 2018, 2019 to 21, 2022. My lord has got that? I'm sorry, my lord. I'm sorry, my lord. Page 326, the first page of the show cause itself, paragraph 1I.
Yes.
Your lordship will find that the demand sought to be raised, obviously at the end of the adjudication, is in excess of 17 crores, but the period involved are multiple tax periods. My lord has got that? Financial year 2018 to 21, 22. Then my lord will kindly take II. Again, this is on another ground, that is availment of excess ITC. Again, my lord, your lordship will find the period involved in is multiple tax periods, that is 2018, 2019 to 21, 4 years. But the primary ground which I am on the basis of which I am challenging the show cause, which we have taken in the grounds of the writ petition, is that there cannot be clubbing of tax periods when a show cause notice is issued under section 74. The authorities have invoked section 74 of the CGST Act. Now, your lordship knows that section 74 vests the authority with the power to invoke the extended period of limitation. That is for a period of 6 years in total. 6 years in total. 6 years in total. So, my lord, your lordship will find, having regard to the provision contained in section 74(2), read with section 74(10), my lord, all the show cause periods are referring back to the date of filing of annual return. Your lordship will find that in the text of section 74 itself. Now, my lord, there are 5 high court judgments when it has been held categorically by different high courts that this clubbing of show cause periods cannot be made. A single show cause cannot be issued for multiple periods. And for which reason, my lord, the show cause, even the orders have been quashed and or set aside. This is one. Well, I've got the authorities. Second one is that now your lordship will kindly come, well, because I am not here. This is it court. Well, I am not here to trouble your lordship with the facts of the case. Second point is that my lord will kindly come straight away to brief facts of the case.
Yes.
327. Now your lordship will kindly skip over and take, my lord, page 330. Your lordship will find, kindly take paragraph 2.2a. My lord has got that?
Yes.
On scrutiny of taxpayers GSTR 3B, GSTR 9. Well, GSTR 3B is the monthly return. GSTR 9 is the, my lord, the annual return. And auto drafted, my lord, that is an auto populated data available in GSTR 2A, excluding RCM supplies, data retrieved.
GSTR 9 is monthly.
Yearly, my lord, yearly, annual return. GSTR 3B is monthly. Now, my lord, what I'm trying to draw your lordship's kind attention to the, my lord, the observation or, my lord, the fact recorded that on scrutiny of taxpayers GSTR 3B, GSTR 9 and GSTR 2A. Now, my lord, scrutiny, the procedure for scrutiny has been specifically laid down in section 61 of the Act, which has to be read in conjunction with Rule 99 of the CGST rules, for which, my lord, relevant notices are to be issued by the authority and in the prescribed form, not my lord any other notice, in the prescribed form, and the assessee or the RTP, as we use the expression, your lordship may now, your lordship, it is, my lord, the registered taxpayer is required to respond to such notices again in the prescribed form. My lord, no such notice in prescribed form following the procedure laid down in section 61 read with Rule 99 was followed. In fact, my lord, two documents I will just show. Kindly take page 50. Volume 1. 50 and 59, nothing more. But this entire exercise is not, my lord, it's not a one-day affair. My lord, the correspondences were being exchanged by and between the parties. Notices were being issued. Kindly take, my lord, now. After, my lord, the first paragraph itself.
Yes.
But this is dated 18th of May 2023, pertaining to one of the relevant period. As per section 61 of the Act, my lord, even this is the audit inquiry reference. As per section 61 of the CGST Act, various returns filed by taxpayers have to be scrutinized by the proper officer to verify the correctness of returns, and suitable action has to be taken on any discrepancies or inconsistencies reflected in the returns. The proper officer designated for this purpose is the range officer. So this is regarding, my lord, the mismatch between ITC, between annual return, that is 9, and financial statements, that is, my lord, GSTR 2, 3B and 2A. Now, my lord, kindly now take again 59. This was the issue number 2, for which, my lord, a demand is sought to be raised in excess of 21 crores. Now, my lord, kindly take now page 59. This is, my lord, regarding mismatch between the e-way bills and, my lord, the GSTR 3B. That is issue number 1. Again, my lord, the first paragraph at page 59, as per section 61 of the CGST Act, various returns filed by the taxpayers have to be scrutinized by the proper officer to verify the correctness of the returns, and suitable action has to be taken on discrepancies or inconsistencies reflected in the returns. The proper officer designated for this purpose is range officer. But there are at least 2 High Court judgments that, without following the procedure laid down in section 61, read with Rule 99, no show cause notice could be issued under section 74 of the Act. And, my lord, to top it all, my lord, the show cause notice itself says that as per scrutiny of returns, when actually no scrutiny of returns has been done following the procedure laid down in section 61 read with 99. So, these are jurisdictional excesses which I am trying to point out before your lordship. Straight away, 5 judgments. Well, I prepared a compilation. 5 judgments on the issue that clubbing of tax periods cannot be done. No single show cause axiom. Clubbing of tax periods cannot be done, and no single show and no single show cause notice could be issued for multiple tax periods. One of the judgment is, my lord, this is first is, may I place Mill Rock, this page 27 of the, my lord, the compilation. Kindly take, my lord, paragraph 19, page 33.
Page 33.
Yes, my lord. Following, my lord, Madras High Court judgment, and there is also a judgment rendered by, my lord, the Andhra Pradesh High Court, AP High Court. It clearly says, my lord, The Act of 2017 therefore involved my lord has got that definite tax period based on filing of return. So it is a return triggered my lord proceedings. My lord, on the basis of filing of return, based on filing of return, which can either be monthly or annual return.
Bunching of show cause notices is
Yes, not permissible. Now, my lord, again on this issue, Andhra Pradesh High Court, again a division bench judgment. Kindly take paragraph 17-18. So Andhra Pradesh, ST construction. Page 44. Page 44. We are of the opinion that a single show cause notice or a single
page
44. I am so sorry, my lord. It is paragraph 17 and 18 at page 44 of the compilation.
Yes.
The my lord, this is there, and there are a couple of 3 more judgments which we have also annexed to the.
No judgment of our court.
My lord, there was my lord, there was a challenge was thrown to an adjudication order when my lord, on the ground that it involved multiple tax periods, but the honorable single judge, the coordinate bench said that you did not approach the honorable court at the stage of show cause, you approached the court at the stage of adjudication order. So I cannot interfere. But as an officer of the court, it is my duty to point out whatever is the order. That's how order down. We have got that order. 2. Kindly take. Kindly take, my lord, admittedly in this case, paragraph 3, after the show cause notice was issued, the petitioners did not approach this court to challenge the same. It is only after the final order dated so and so was passed, under section 70 was passed, the petitioner approached this court. Well, I am here before your lordships at the stage of show cause notice itself. And my lord, hearing notices are now staring at us. The next date of personal hearing is fixed on 7th. Now, my lord, on the issue that, my lord, section 61, red with rule 99 would have to be followed. Well, kindly take paragraph 9. As rightly pointed out by Mr. Siddiqui, learned AGP, the aforesaid judgments have been delivered under section 73, be that as it may. Well, I have brought judgment under 74, in fact. Be that as it may, taking into consideration the fact that the petitioners have an efficacious alternative remedy, all such issues which the petitioners seek to raise can be decided by the appellate authority. I am of the view there is no scope for to entertain the petitioner, having regard to the fact that the petitioner at the first instance after the show cause.
This was not decided.
This was not decided. So this is to be decided. And the second issue, for which I have also got authorities in support thereof, my lord, kindly take, my lord, 2 judgments straight away. Kindly take, my lord, this Govardhan Dham. The bolo page bolo, page 60, page 66. नहीं गुजरात हाई कोर्ट वाला है ना गुजरात हाई कोर्ट बोलो पेज 66 नहीं राजस्थान हाई कोर्ट that is page 66. I am sorry, mother, page 66.
Yes. Page 66.
Paragraph 25-26.
Page 69.
At pages 69. But the judgment rendered by, my lord, this Rajasthan High Court was followed by, my lord, the Guwahati High Court, which is at page 55 of the compilation.
55.
55. 55.
51 stay on.
My lord will kindly take, my lord, even a stay order was passed in that case. 51 is the stay order and 55 is the final judgment rendered by Guwahati High Court. Paragraph 25 to 27, 28 and 33. 28, 33. And my lord, this judgment, Supreme Court, my lord, the Rajasthan High Court judgment was challenged in before Honorable Supreme Court. The Honorable Supreme Court was pleased to dismiss the SLP. That also we have included in our compilation. Page 70. And my lord, why I'm trying to supply much emphasis to this scrutiny of returns, because my lord, so far as my lord, the second issue is concerned, it says that on scrutiny of returns, when actually no scrutiny of returns was made in terms of section 61 read with rule 99.
No, is there a procedure for a scrutiny?
Yes, 99. Rule 99, your lordship may kindly take. My lord, that is there. In my compilation, it is there.
Page 6.
Page 6. গোবর্ধনটা হচ্ছে তোর প্যারাগ্রাফ, জাস্ট 1 মিনিট, প্যারাগ্রাফ গোবর্ধনের প্যারাগ্রাফটা বলো। মানে পেজ 1 is section 61 দিচ্ছে এক্ষুনি বলছে। Page 61 is page 1 is section 61 scrutiny of returns and page 6 is rule 99 scrutiny of returns.
That you are supposed to be issued a notice.
Yes, in ASMT, my lord, 10, and I will respond in ASMT 11, and my lord, the final decision will be taken in form GST ASMT 12, and then only they will issue show cause notice. So my lord, I am at present, my lord, though interim order cannot be a binding precedent, but I would beseech your lordship, having regard to my lord.
Hearing is only tomorrow.
Hearing is tomorrow. Yes, yes.
Yes, Mr. Kundalia.
Hearing notice. This is the hearing notice.
But he has a hearing tomorrow. Postpone it.
I have a hearing.
No, you postpone the hearing. I'll take it up when you are ready. Don't take the hearing tomorrow. I'm not staying it. I'll just observe that you postpone the hearing to tomorrow.
Yes, madam.
That will help both.
Yes.
Both the parties.
Yes, yes, yes.
Instead of staying and then
No, we've done obviously.
Primary point.
Right.
I don't see this given by the Director General of Audit with the central controller of Auditor General that not from the one. What does it say? As per 61 of the CST Act, various returns filed by taxpayers have to be scrutinized by the proper officer.
Yes.
Verified here that proper officer. Yes, proper officer.
Rain superintendent.
Proper officer.
Yes. Compilation-ই আছে, দেখে নে।
The primary since I have not considered the judgment that my lawyer has said. Before I show section 61 guidance, I see the page 327 for same
327.
327. Now I don't try. During the course of the subject specific compliance audit conducted by the officers of the Director General of Audit Section Kolkata. It was revealed. So it was revealed on the basis of the audit that was made by the central audit. It was revealed that IBL Policery had short pay GST during the period from 1920. The short payment arose under declaration of outward taxable supplies in their GSTR duty return as compared to the details reflected in the e-way for the corresponding period. In order to assess the extent of such discrepancy, a detailed verification was conducted for the period 1819 to 2122 by comparing the outward taxable supplies regarding GSTR with those recorded in the e-way portal covering the said core financial. So, based on that information that has been got by the audit, audit said there should have been a 61 by the proper officer. This information was got by me. I had done the verification, and based on that, I had.
No, but
But the second one, page 330.
Mr. Mojumdar's submission is that whenever you do the verification or the scrutiny, whatever the term may be, the scrutiny has to be done in a process that has been identified in Rule 99. It says that Rule 99 says that whenever you find that there is any discrepancy, then you issue a notice.
No, madam, because in this matter,
Circular निकालो.
so there are three.
कहाँ shall?
No, Rule 99 says shall.
Shall, not may.
Shall.
And there is a departmental circular. The CBIC instruction is also there. How it is to be done?
Page 11 of my compilation. It's there in the compilation.
Compilation page 6. And the other point, whether clubbing of periods are there, is there.
That was I have contrary Ambika.
Which one? But Ambika has been considered in Bombay High Court by Bombay. That was considering fraud.
This is only if there is a 61 procedure that is proceedings that have been conducted.
Yes.
Only then 99.
Yes.
Yeah. The 61 is not the only procedure by which action can be taken against any. It can be done through information. This can be done through post 61 scrutiny. This can also be done
without 61 scrutiny.
Yes. Yes.
Because of
there is fraud suppression. Fraud suppression one can always.
But fraud is not even the case made out in the Shota.
Suppression is better.
Fraud is not. But I am not on merits right now. I am not on merits. I have not argued on merits. No, I have not argued on merits. I have not argued on merits.
I am saying why it is suppression.
No. I have not argued on merits. Perhaps, I have not been able to make myself clear to my learned friend.
So, under three circumstances, action can be taken. One is post proceeding under 61. One is after audit under 65. The 65
You
not
audit.
We have not done the audit. Audit has been done by PAD. After independent information from internal source. In this case, it's why I showed the very outset. The information given.
Instruction.
So that's an external information. We have found to internal verification and we can accelerate it. And there's an opportunity given to them also. That this is the demand. You give me the come and be concerned.
Where is that? Where is that?
Yes.
Intimation and our response to same time.
My learned friend is referring to a notice under section 74(5) for which we sought time, but without waiting for the granting any adjournment, straight away show cause notice was issued. Yes, DRC 01A is there. DRC 01A is at page, may I just give you a lordship, page is 313. We sought for time.
321 is the time petition.
And when the law is well settled, that even if I don't respond to this DRC 01A, it doesn't mean, my lord, I cannot challenge the show cause notice.
You always have the right to challenge.
Yes. And I prayed for.
Point that we have made out a clubbing. One is clubbing and the other one saying that scrutiny has not been done. And I showed my lord that this scrutiny here, what written by the CAT. I have not initiated scrutiny under 61, and it is not my humble submission is not that without scrutiny I cannot initiate action against it under different circumstances. If I have got information based on which I placed before my lord, it said that this is the information that I got from that. Based on the information was other years, and then we found that this
No, but the letter of the Auditor General or whoever, that letter does not give you any information. It only says that you have to scrutinize the records in terms of section 61 to.
my lord, can you see these are the discrepancies that
Page
51.
Page 51.
They said reasons for irresponsibility. So this is the information we have got.
No, but Mr. Kundalia, page 50, the penultimate paragraph above the chart at the bottom of the page. The paragraph beginning the data sets.
The data set pertaining to
Yes, kindly see the last line. Further, in case of non-reporting or under-reporting of taxable supplies, details of action taken under section 61 of the CGST Act may also be intimated to the recorded. So you say that you have not taken any action under section 61.
may also be intimated to audit.
Then how do you get the information?
Based on this information, this was the information that we have got from CAT. CAT can say that there can be audit, but we have done our verification and found that this is the liability that which is why we issued a DRC 01A. Now DRC 01A is not a notice, it's an intimation. Intimated to that's when we sought for
That is an intimation to procure his response
yes.
on the discrepancy that according to you has occurred and which requires an explanation. So what is the explanation given?
Doesn't make sense. I won't be given 5 because the assessment is that he said he wants more. He said he wants 30 days time to give. So we issued the show cause. That also issuing the show cause is also gives that opportunity. He doesn't want to take the opportunity. And 5 days is a reasonable period for this.
Very well.
But may I just respond? Quick response.
No,
Kindly take.
I'm going because he's not going to conclude. He
Right.
have to take time for the judgment.
Right.
What he indicated.
Right.
So in any case, we are not concluding. No use wasting
Right.
time.
No need.
On the other part of the judgment also, I don't find it one of the judgment.
So since you are not concluding, Mr. Kundalia,
Does it still have
Yes, everything left.
yes, he will begin again with fresh energy on the next.
But I've just taken out a bone from the closet. Now the entire skeleton will have to be brought out of the closet.
This repetition assail, a show cause notice.
instead of giving us stay away?
I'm not giving a stay. I'm asking you to postpone the hearing. I said that at the very beginning.
Yes.
I'll not stay. show cause notice dated June 24,
No,
2025.
order हो रहा है
Show cause
राहुल, you
notice
can't.
demand
This is a High Court
dated
order,
June 24,
and
2025.
the people is there, the
Issued
councils
by
are there.
the additional commissioner, comma, Haldia commissioner, Haldia commissionerate. This show cause notice come demand is under what? Section 74.
74(1).
Show cause notice come demand under section 74(1), 74 bracket 1 of the CGST Act, comma 2017. Issued by additional commissioner की बोल लो, Haldia commissioner, full stop, paragraph. Mr. Mojumdar, learned senior advocate appearing for the petitioner, submits that the show cause notice is not sustainable, at least on two grounds, full stop. It is submitted that the show cause notice has been issued by clubbing 4 financial years, i.e. financial year 2018-19 to 2021-22. Such clubbing of financial years is impermissible in law. Full stop. The second ground to assail the so cause notice is that
तो कौन सा जजमेंट बोला है क्लबिंग के लिए दिल्ली वाला? हम दिखा देना हमको।
the same has been issued without conducting the inquiry, scrutiny in terms of section 61 read with rule 99. There is section 61 of the said act of 2017 read with rule 99 of the CGST rules. CGST rules
2017, my lord. 2017.
2017. Full stop. He has relied on a judgment. He has relied on the following judgment. এখানে ये देना citation. Support of his contentions. Full stop. Mr. Kundalia, learned senior advocate appearing for the respondent CGST authorities, submits that clubbing of financial years is permissible under the law, and that bunching of notices, bunching of several years would not invalidate a show cause notice. Full stop. It is further submitted that in the instant case, the show cause notice has been issued on the basis of information provided by the
DGARM.
Mr. Kundalia, your submission was the notice has been issued on the basis of information provided by this.
It is DGARM.
The Director General of Audit. Director General of Audit within bracket Central, Kolkata. Full stop. It is further submitted that in cases falling under section 74 of the CGST Act, 2017, scrutiny or inquiry as necessitated under section 60, as required under section 61 of the said Act, is not always necessary, and that a show cause notice can be issued even without conducting such inquiry. Full stop. Conducting such inquiry. Full stop. Upon receiving appropriate information. Full stop. Paragraph. He relies on so that I can also come ready.
Yes, 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 ma'am. We will get it. কি নাম এটা? অম্বিকা। এটা কি আছে?
He relies on reported it.
Party did not press.
Respondent লিখলাম এখানে।
এটা considered in Bombay.
Mr. Kundalia takes time to
ठीक है, बाद में देखेंगे।
go through the judgments cited by, go through the other judgments cited by Mr. Muzumdar. Full stop. It is submitted by Mr. Muzumdar, learned senior counsel appearing for the petitioner, that the hearing in respect of the show cause notice is fixed tomorrow. I have not noted in detail because I'll be revisiting. Yes. Paragraph 40.
There was a dissent.
That doesn't carry us anywhere.
Same thing in SLP, dismissed without notice.
There is one distinction, my lord. One distinction, my lord. Withdrawn means non-prosecution, and dismissal means at least some papers have gone through.
It remains the judgment of the division bench only.
But your lordship, may I just inform just a digression for a moment. One matter, Mr. Kundali is opposing me in a 260A matter. This is a customs appeal. In a customs appeal, where we find a judgment of the Punjab Haryana High Court, which was carried to my lord Supreme Court, and the Supreme Court Lok Adalat has decided the issue.
So that can be decided.
Well, when I got the order from the server, I was amazed. It's a 5-member Lok Adalat of Supreme Court, headed by former Chief Justice of India. Many lesser, many
ultimately like settlement.
In a revenue matter, my lord. In a revenue matter.
Hearing is fixed tomorrow.
Your lordship will also appreciate the interest in our courts other questions. The honorable judge is not sometime after hearing, when the matter is going against them, they give them that opportunity to withdraw, and that has they withdraw under such circumstances.
So nothing is settled.
Because exactly.
Hearing is fixed tomorrow. Full stop. Since there is no hearing is fixed tomorrow. I am recording his submission. Since this court is hearing this petition, and the hearing has not been concluded today, comma, the respondent CGST authority, who is to conduct the hearing tomorrow, i.e. November 7, 2025, comma, is requested to postpone the hearing to a date later than the date on which the instant writ petition is made returnable. Full stop. Paragraph. List this writ petition for further consideration on
13th, 14th, whichever day, my lord, suits your
14th is Friday. I'll be taking up
13th, my lord. I was just your lordship will be taking up the public premises matter.
13th, yes.
That's
public premises.
It is entirely up to your lordship's, my lord. Whatever your lordship.
You can have it on, because Public Premises Unauthorized Occupants Act, I have only 2-3 matters.
Very well, man. 13th, let it be on 13th. 13th.
Because he'll be fixing a date after 13th. So
right.
He will not fix 14, I suppose.
No, 2 p.m. No? First have it, huh? But your lordship is now sitting, sitting in a division bench.
For today only.
For today.
Not for.
At 2 p.m.
So minor than 2 p.m.
The 2 p.m. position. Our primary family is
it will be there in
they
the
will
list.
be there. We will arrange them. But if anybody. But if we are otherwise, we are.
Yes, yes, definitely. That goes without saying. দিদি এটা সার্ভার আজকে যেতে তাড়াতাড়ি হয়ে যায়, কারণ কালকে হিয়ারিং আছে।
মানে you include the server copy and
server copy.
হ্যাঁ
More than us, their email will be more efficient.
ठीक ठीक ठीक
Well, it is that matter where I indicated before your lordship that I made some imports and the upload was not done. So I requested my learned senior friend opposite to take a report from the custom authority.
Yes, Mr. De.
We have taken instruction from the department. The department says that 8 bills of entries are in question. Out of 8 bills of entries, say, and in 7 bills of entry, duty has been paid along with IGS. But those seem to be processed manually. And the reflection of that in the GST portal is not there. Therefore, any short of further clarification from the account section. The official also kindly keeps it or further constitution next week. We shall again come up with further written instruction from our account section.
Well, in the meantime, only I believe they have not yet. The GST authority will not take any coercive action.
Mr. Sanyal, it's there before the court. Don't take.
Yes. If Mr. Shan,
because stay, I'll have to hear it. That is the problem.
It will be convenient for us if you kindly pass even a short off.
I will pass that.
with a direction upon the custom to, well, I don't want my learned friend to take the burden. Let a report come. Let a report come in black and white from them. And in the meantime, state GST should not take it.
Your Lordship, I am representing the respondent number 1 in this matter.
Very well. Mr. De, at the outset, Mr. De, learned advocate appearing for the Customs Authority, submits on instructions that although 7 bills,
7 bills of entry. There are totally
that although 8 bills of entry are in question before the relevant authorities, it appears now apparently duty along with IGST has been paid in respect of 7 out of those 8 bills. However, full stop. However, since processing of such payment has been made manually, the records therefore are not readily available. That is it.
No.
They are not reflection of the GST portal.
Therefore, the same have not been reflected in the GST portal. Full stop. Mr. De submits that in order to come up with clear and specific instructions on this point, he needs some time. Full stop. In such view of the matter, who is the authority?
Well, GST custom. Custom port, my lord. The Commissioner of Custom Port, respondent number 7.
The respondent number 7,
through his authorized officer, will pass,
is directed to file a report before this court as regards the payment of duty along with GST in respect of the 8 bills of entry which are in question before the relevant authorities on or before the returnable date. Full stop. Should I do it in the form of affidavit or
no?
Only simple report will suffice. And also only one sufficient of instead of directing the report number 7, also can you also add the authorized officer
the report number 7 or his authorized agent or an officer authorized by him or an officer authorized by him. That is the paragraph. Since the issue as regards payment of IGST, as regards payment of duty along with IGST and non-reflection thereof in the GST portal prima facie appears to be because of manual processing, comma, it is expected, comma, manual processing, comma, as submitted by Mr. De, comma, it is expected that the respondent GST authorities shall not take
already attached my account, what I'm submitting. They've attached, let it remain attached, let them not record.
Shall not take any further coercive step during pendency of the petition before the returnable date. Before the returnable date, it is submitted by Mr. Sanyal, learned advocate appearing for the respondent GST authorities, that where is that DRC?
That is in my application. Application page 15.
Application টা নেই রেকর্ডে আগের ম্যাটারে রয়ে গেছে
Can one
আগের ম্যাটারে হ্যাঁ এটাও রয়ে গেছে আগের ম্যাটারে দিয়ে দাও DRC 13.
Yes, they have issued to the bank
that a notice under section 79 within bracket 1 within bracket C in form FORM GST DRC subcaps -13 has been issued. Full stop. It is expected that the authorities would not proceed to recover any sum in terms of the said GRC, in terms of the said notice before the returnable date.
No, not recovered, not yet recovered. I've taken the instruction. They have not yet recovered anything, only attachment is.
আচ্ছা তার এর আগে একটা লিখে Mr. Chakraborty, learned advocate appearing for the petitioner submits that there has been no but it becomes all ifs and buts. You submit something, he submits something.
No issue, my lord.
I will stop at that. No coercive action.
Correct. Correct.
Mr. Dev submission to recorded. Because there will be a lot of ifs and buts. If this, if that, not good. Prima facie appears to be to have happened because of manual processing. Further coercive. Bas, that's it. আর কিছু দাও
Returnable.
When?
Whenever your lordship.
7 days time. 7 days time will take us to 13 again. I'm putting it on 17th.
On 17th.
List this matter for further consideration on November 17th. So I'm not recording anything about DRC 13 issuance, no further coercive action.
Your Lordship, if my presence can be recorded, Your Lordship, grateful.
Presence is recorded. You give it in your chat box.
Yes.
Nobody's running away. Whether I am running away, the authorities are running. Even if they recover and tomorrow it is found that I am not liable, they will refund. Hardly matters. Deeply obliged.
It's a item of 2019-20 matter. In this matter, all started with scrutiny and thereafter undergone the intimation, show cause notice, and thereafter the final order. In final order, my lord, three issues were raised, my lord. One is regarding
Means adjudication order.
adjudication order.
So why have you not preferred appeal?
We are preferred of appeal, my lord. After that,
Appellate
appeal,
authority's order.
I am against the appellate authority.
What is wrong with the order?
Appellate authority rejected the appeal on the ground of limitation.
Oh.
My lord. Yes, my lord. My lord, in the appeal, my lord, it was rejected on limitation, my lord. In this,
How many days delay was there?
47 days, my lord. 47 days delay. In this regard, my lord, I have two explanations, my lord. What
was the explanation given before the appellate authority?
My lord, appellate authority have show cause annexed at page 37, my lord. 37.
Yes.
But the petitioner was unaware about the show cause, my lord. Because, my lord, the show cause
Where have you written that?
37, my lord.
37 is appeal to appellate authority. Yes. Which page? Page 37 is not the page.
My lord, I have the copy of the show cause. Probably it missed, my lord, in the your lordship's copy. The show cause notice itself was appeared in the portal, my lord, under the heading View Additional Notice and Order. There are two limbs, my lord, in the portal. One is the View Order and Notice, and another is View Additional Order and Notice.
This is the show cause notice. Where is your explanation? I'm not asking for this. I'm asking for an explanation for delay. Where have you explained the delay before the appellate authority?
No, appellate authority, my lord. I'm taking it.
Before the appellate authority, when you approach belatedly,
Hmm.
you will have to explain that you have approached belatedly. Where have you done that? That is the question. Paragraph 11 of?
Good.
Don't get embarrassed and don't get afraid. Find out, tell
my lord, kindly come to para 7 of the writ petition, my lord.
Read petition.
My lord.
Para 7 is not the answer.
My lord, kindly fix another date. My lord, I am not the matter he has got. I am not matching, my lord. Probably the
An adjournment is prayed for on behalf of the petitioner. Full stop. This is the matter for further consideration on. When do you want?
my lord, on Monday.
Monday. On November 10, 2020. Go through it. Get ready. Come back. I'll come back in
all
5
right.
minutes.
My lord.
Yes. Yes.
This matter is under service tax. And I am before this honorable court after a fresh adjudication order has been passed pursuant to the appellate order previously passed. And I am before this honorable tribunal, honorable court, because there are several fatal jurisdictional errors and omissions committed in this proceeding, my lord. That is why I am before this thing. The first of the challenges that the officer who took the proceeding lacked territorial jurisdiction. Like the scheme under the service tax is connected with excise, and they are divided into several divisions. Initially, when I was first registered, I was under Bazar division. Bazar division spreads over several KMC wards. Subsequently, I shifted to Bidhan Nagar municipality area, which is not the KMC area. So I went beyond the jurisdiction of the Bazar division. And this fact, they knew well before the initial show cause notice was issued to me. They have taken note of it, where I was and where I am now, because my notices are coming to my current address and they are mentioning where I had been. So there is a lack of jurisdiction because no ward of Bidhan Nagar municipality falls within the Bazar division. Officer has been passed, order has been passed by a superintendent of Bazar division, my lord. The notice was issued, heard, proceeding was concluded, everything by the superintendent of this. This is first. And that jurisdiction I get from this notification, my lord. আপনাকেও দিতে হবে আপনাকে দিত
What is the scheme of the act?
It is connected with excise.
Now, where is the act under the act? How is the jurisdiction decided?
This is the notification which determines
This must be in terms of some section.
Section list of jurisdiction. This is it, my lord. The available notification does not give.
There should be an empowering section according to which this exercise is execution of the law which is mandated in which is.
So whatever the jurisdiction in excise, that is followed here, my lord. And kindly see page 2 of this notification, my lord.
Yes.
Serial number 10. Bazar division. Ward number 25 to 38 of Kolkata municipality.
My question is on the issue of the section, because if for administrative convenience there is a division, then in that case that will not amount to inherent lack of jurisdiction.
My learned friend maybe is in the better position to.
If the jurisdiction is something which is vested in the authority by dint of a provision of law, then in that case that is inherent, that is qualitative jurisdiction. Lacking of that jurisdiction will be a jurisdictional error. But if it is only for administrative convenience of the authorities concerned, then in that case that will not be a jurisdictional error.
For now, my submission would be that my learned friend is in a better position to make submission on this, because this particular law has been long hibernating. So I will take maybe another day to find out how this scheme is actually working under the in connection with excise and service tax. This is first challenge. Second challenge is that this order which has been passed by superintendent is against the subject matter jurisdiction, my lord. It is also beyond the subject matter.
Why?
Because initially superintendent was not given power to adjudicate. it was sometime later on that the CBIC decided that yes, we will confirm some power to adjudicate on superintendent. So they passed an order. But in that order, it is specified that superintendent will not be exercising any jurisdiction in respect of cases where extended jurisdiction is invoked. This is that circular, my lord. The very recital says, my lord. The very recital at the beginning says so.
Say monetary jurisdiction is not there.
Monetary has been subsequently revised, but I am not on the monetary part. I am part on the
Monetary only involving service tax up to rupees 1 lakh.
in a show cause notice, except in respect of, I am on the exception part, my lord, except in respect of issues relating to taxability of services, valuation of services, and cases involving extended period.
So superintendents will not have jurisdiction in respect of taxability of services, valuation.
Whatever they say, I am only saying that since in my case they have invoked extended period of limitation, that is why it is out of jurisdiction.
No, but this says the otherwise.
The board has decided to confer power of adjudication on superintendents for cases involving this 1 lakh in a show cause notice. This is the power conferred. Except this is the
so your case
falls
is,
within the exception. I am falling within exception.
So your case should not be decided by
superintendent, my lord. And it is the superintendent who has decided this issue from the beginning till the end. So that is question number 2, my lord. This third challenge also, maybe this order is barred by limitation. Maybe not, it is not a specific provision, but the scheme of the act will lead to this.
What is the date of this order?
No, date of order is, last order is 29/10/24, my lord. 29/10/24. Fresh order, and it is at page 53, my lord.
The order under challenge is this order.
53. Next is the case that perhaps 73(4)(b), the scheme is such that once a show cause notice is issued, and if it has to invoke, if it is invoking extended period of limitation, that has to be completed. This book will not help, my lord.
Census Sales Act.
No, this is service tax.
Service tax.
This book is there.
I have service tax.
Service tax.
Yes.
Section, the scheme as per section 73(4)(b) is that where limitation, extended limitation is invoked, that is 2i, item 2i of such subsection, then it has to be completed within 1 year of the relevant date. Now, show cause
73
4b.
4b.
B.
Within 1 year.
Within 1 year. 2i. Within 1 year. Now here, initially when the show cause notice was issued, it was completed. But that that order was set aside. Now fresh adjudication came. So in my humble submission, a period of 1 limitation from the last order, that is the appellate order, should also apply to this, because the entire scheme is trying to finish the matters within a time frame. In this case, the appellate, after about 1 year, 8 months, the appellate order, this fresh order has been passed. So presumably under the scheme of the act, though there is no very specific provision what will happen after the appellate order has been passed, in my humble submission, this is barred by limitation. Fourth challenge is on clubbing of periods, my lord. And a lot of arguments were made on this point today. Clubbing, because this proceeding is also clubbing year 2014-15 and 16-17. So that is another challenge. And another challenge is that whenever extended period of limitation is invoked, this scheme is continuing from under all the pervading all the acts, excise and customs and service tax, now GST, that if it is invoked, there has to be an allegation with evidence, prima facie evidence, that there has been some willful suppression, there has been some fraud, there has been some this thing. In this case, there is no such allegation. It is only bare a half-line statement that dealer has suppressed. Nothing, no discussion, no evidence, no instance cited. So on all these grounds, another fatal mistake has been committed, because I am engaged in providing security service. And under the scheme of the Act, by the notification number 30 of 2012, the liability to pay tax in respect of services provided is on the recipient, on the RCM basis. They are levying tax on me. So all these lacuna in the proceeding, in the assessment, and in the thinking of the departmental authority has brought me before your lordship.
Yes, Mr. Bhattacharya. Whatever, these are jurisdictional points, you can take it even now. Where, how do you get that it is administrative or not? You tell if there is an administrative, you show he has taken a point of. No, Mr. Bhattacharya, you demonstrate before me from the act or the section how determination is then conferred. This note, do you say this is not there? So you have to come up with something that this notification is there or not. That has to be shown from the law. Take me to the jurisdictional section, which is the section which speaks about conferment of jurisdiction.
There is no such provision as such. There is no such provision. Only application of the rule of the department, not based on anything or on
very well. Next.
Next point is that anyway, board has decided to confer the power and superintendent for cases not in administered up to 1 lakh except in cases of distinct. Therefore, the cases have been kept in the domain of the superintendent.
No. It says board has decided to confer jurisdiction because you read the earlier cases. Present adjudication power in service tax cases have been delegated up to the level of assistant commissioners, and superintendents are not vested with any authority to adjudicate cases. But by this notification, superintendent is vested to adjudicate case only if the monetary limit is up to 1 lakh, not beyond that. That is the meaning. No, but we don't need to go to the next because this. So if
here on the so-called issue on the basis of distance,
if the case is in respect of issue relating to taxability of service, which is his case.
Taxable or not, that issue has been decided there.
So that cannot be decided by superintendent because it is except in cases that is accepted. The jurisdiction of the superintendent is confined to cases having monetary limit of 1 lakh, but from that bracket also this issues relating to taxability of cases, valuation of services in extended period, all these things are three things are excluded from that bracket. The bracket, that is what the language prima facie reading of the language says. Where comma has been given? Because comma has to be given. 1 lakh in a show cause notice, then except in cases. So those cases are accepted. Then accepting that expression becomes redundant. It becomes meaning. What are you accepting then? If the issue relating to taxability of services is also to be decided by the superintendent, then exception should not be used. The use of the expression except in respect of cases means that those are to be accepted, excluded. No. That is why the 1 lakh will in respect of everything that will mean. For example, case relating to taxability of service can also be one which has valuation of only rupees 50,000. That will be decided by a superintendent if you put a full stop there. But even if it is within 1 lakh, it will not be decided by the superintendent if it is falling within any of these three exceptions. That is what the meaning is. Come back next week then, Monday, because this is just. Jurisdictional issue, that I can answer just now, because there are several judgments. This is a jurisdictional issue, question of law. This is inherent lack. If it is accepted from your jurisdiction, you don't have jurisdiction and you exercise it, it is inherent lack. That is inherent lack. Administrative, yes, definitely I am with you, because that point was raised by the court also. Territorial jurisdiction may not be a ground, but where there is a clear exception, that is, and what about the other one, limitation and clubbing? Come and answer then, because he has raised 6 points. That is on facts. I am only on these aspects, which can delineate. Very well. Very well. Affidavit of service filed today be kept with the record. This writ petition assails. The order which has been impugned in the writ petition is not appealable.
Appealable, but because of the jurisdiction, the last.
No, but he has raised a ground of appealable within what time?
Maybe 3 months, maybe 3 months or 60 days.
No, then how is the delay explained before the writ?
It is explained, my lord. It is explained there, and maybe jurisdiction, because
no, only jurisdiction will not do. You have to explain the delay also.
Delay is also explained in the petition, my lord.
Because writ petition beyond the statutory period, I am a little strict on that.
The person who was looking after the matter, he expired, my lord. He died. That has been stated.
Where is that?
That is stated, my lord. Paragraph 22, my lord, page 14.
Yes.
And not only that, but they even appear with authority, right? 5 times was given. 4th time extra time has been given. Nobody turned up except finding one reply.
The order is of December, 29 December, and 8th November he expired. So 1 week. This is good enough. This is good enough.
That man had been appearing in the proceeding also. His name will appear in the orders and all those things.
He had been appearing in the proceeding. The same person had been appearing in the proceeding also. Mr. Bhattacharya, better ground. This is not the ground to interdict. This was a ground taken by the court. Now you are vociferous on that.
In past order, these issues were not raised by him.
I have said that in jurisdiction, not required in jurisdictional issues can be raised even in the Supreme Court at SLP stage. These are grounds which go to the root of the matter. It can be raised at any time, even in second appeal before the Supreme Court in SLP anywhere. These are grounds which can be raised anytime. Yes. This writ petition assails an order dated October 29, 2024, passed by the superintendent. Superintendent under section, which this is under which section? Passed by the superintendent, comma CGST and CX. Full stop. Paragraph. Mr. Khan, learned advocate appearing for the petitioner, submits that the order impugned suffers from several jurisdictional as well as other errors. Full stop. Full stop. It is submitted that the petitioner's case could have been adjudicated only by an officer, by a competent officer exercising jurisdiction over which area?
Bidhan Nagar division.
Exercising jurisdiction in respect of Bidhan Nagar division. But the petitioner's case has been decided by the superintendent having jurisdiction over Bada Bazar division. Full stop. Paragraph. It is next submitted that in terms of a circular bearing number 130/12/2010-ST capital dated September 21, 2020, superintendent had been conferred power of adjudication by the board only in respect of cases involving service tax, involving theke inverted comma involving service tax up to RS dot mane rupees dot 1 numerical lakh LAKH lakh.
This limit has been
in
increased
a show cause notice, comma, except in respect of issue relating to taxability of services, comma, valuation of services, and cases involving extended period, inverted comma, closed. Full stop. It is submitted that the petitioner's case related to your case related to taxability of services.
Taxability of security service. Security, I provide security.
How do you fall within these exceptions?
There is a notification number 30/2012.
Yes, that I have got. You said that it falls within one of the three exceptions. Which exception do you fall within?
The exception there?
Yes.
The exception of invoking extended limitation.
The petitioner's case is one. It is submitted that the petitioner's case is one that involves extended period, and as such, in view of the notification dated September 21, 2010, the superintendent could not have exercised jurisdiction over the petitioner's case and adjudicated the same. Full stop. Paragraph. Now paragraph now likhun. Referring to section 73 within bracket 4 within bracket B of the Service Tax Act, comma, it is submitted that the order passed by order impugned in the present writ petition is barred by limitation. Full stop. It is then submitted that the order pertains to how many financial is order pertains to
1415 and 1617.
1415
1617.
to
There's a gap in
two
between.
periods, namely 2014-15 and 2016-17,
my lord.
which full stop, such clubbing of years is not permissible under law, and as such the order is impeachable on that ground also. Full stop. It is also submitted that the order proceeds on the basis of an allegation of suppression,
Bold allegation.
but there is no evidence in support of such allegation. Full stop. It is the last leg of the submission of Mr. Khan is that the petitioner's case relates to taxability of security services, and in such cases liability to pay tax falls on the recipient of services and not on the provider of services. It is submitted that the petitioner is a provider of service, and as such incidence of tax could not have been on the petitioner. Full stop. Paragraph. Mr. Bhattacharya, learned advocate, appearing for the respondent. Respondents seeks time to make appropriate submissions. Full stop. List this matter for further consideration on 12th, November 12th. 12th অনেকগুলো হয়ে যাচ্ছে নাকি দিদি? না, 17th.
From 14th onwards until 18th, I am not in Calcutta. So either before or after.
19th.
19th, I will be coming back late at night, and 20th, fine.
20th. Affidavit of service টা উপরে লিখে দেবে। Yes.
Well, it is 2018-19 matter. Malad, here is also it starts from scrutiny, thereafter intimation, show cause, order, and petitioner went before the appellate authority decided on merit. My lord, the impugned order is at page 49, my lord. There are two issues involved. That is the ITC availed against the RC cancel dealers, and the ITC availed against certain dealers who have not filed GST 3 GST return, monthly return. So all these two allegations on the fault of the supplier, because I have taken the purchase, I have taken the inward supplies. On that date, they were very much registered. Subsequently, they have been cancelled, and they have certain of them not filed the returns. I have the judgment in my favor, but before that, my lord, I like to take before your lordship the jurisdictional issue involved over there. Here, the proceeding was initiated through scrutiny of returns. And that kindly come to page 31, my lord. The impugned adjudication order 31.
Yes.
Whereas the returns furnished by you under section 39(1) of the WBGST Act and CGST read with section 20 of the IGST for the period 18-19 have been scrutinized. So, my lord, once the returns have been scrutinized, your lordship, I have the discussions in matter 3, the similar point. That's when once the returns are scrutinized under section 61, because 61 is the only section under GST Act which gives the scrutiny of returns. To invoke that scrutiny of returns, the authority must have issued the prescribed notice in form ASMT 10. That has not been issued in this case. And I have taken the point at para 7, paragraph 7 of the writ petition.
Before the appellate authority, you have taken this point?
No, not before the appellate authority. It's a jurisdiction issue, my lord, point of law, man. I have taken before this honorable benchman. And in this regard, my lord, that I like to place before your lordship. The first one is the instruction, departmental instruction, where it is given that to scrutiny, the officer must issue the ASMT 10. In the instruction, my lord, the para number 7, my lord, para 7, sub point 8, my lord, in the table, my lord. The page before the last page, ma'am. Under 7, point number 7, sub point number 8. Within the period of 15 days after completion of the period of 30 days issuance of notice of ASMT 10 or such further period as permitted by the proper officer. And that under rule 99, the corresponding rule, it is mentioned the officer shall issue the notice in ASMT 10. It is the departmental instruction for their officer, they have issued that ASMT 10 must be preceded the scrutiny of returns. And now, my lord, I have placed before your lordship the Honorable Gujarat High Court judgment, where the same issue has been decided in favor of SEC. I have placed, my lord. PepsiCo, my lord.
This is not Gujarat, this is Guwahati.
Sorry, my lord. Guwahati.
This is an interim order.
Interim order. But there are plethora of judgments, my lord. They
yes,
are.
Mr. Chakravarti.
First of all, scrutiny manner 61 kind of. The proper officer may scrutinize the return and related particulars furnished by the registered person, verify the correctness of the return and inform him of the discrepancies noticed in such manner as may be prescribed and seeking explanation. His contention is that this discrepancy was communicated to DRC 01.
Was not communicated.
Was communicated.
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 Was communicated.
Yes.
Yes.
Then what is the problem?
Not in the prescribed format. My lord, kindly
If it
come
is
to the
communicated, then not in prescribed format. Format is not important. Communication is important.
my lord, kindly come to the act, my lord. There are under chapter 12, my lord.
Yes.
There are 6 sections from 59 to 64. 59 is the self-assessment, 60 is the provisional assessment, 61 scrutiny, 62 is the assessment of the non-filers, and 63 is the 64 is the summary assessment. So 61 is only the section where the scrutiny assessment has been given in the act. My lord, kindly consider the corresponding rule, the rule 99.
No, but if they have issued an intimation to you asking for your explanation.
Intimation is coming under section 73, my lord. The proceeding under 73 comes.
Section 73 is also noticed in section 61. Section 61(3).
Section 73.
Yes, both the sections have to be read together.
Yes, my lord. 73 is there, my lord.
73 is the consequence of a scrutiny
Of
under
the
section
scrutiny.
61.
Of the scrutiny.
The scrutiny under section 61 is to inform you about the discrepancies. So that they can get from you the information or your explanation as regards the discrepancies. Upon you furnishing the information or the explanation, they will decide whether to proceed under section 73 or not. That is it.
My lord.
Once that exercise has been concluded, if they have informed you about it, then where is the problem?
No, my lord.
Before the show cause, I have communicated to him before the show cause at the pre-show cause stage. It is not only at the stage of show cause. I have communicated it at the stage of pre-show cause. But that now, my lord, no wrong mentioning of a wrong provision or a wrong form will not reshape the procedure.
My lord, but the procedure must follow the prescribed format, prescribed procedure must be followed. There are judgments, my lord. They might the case is that the judgment probably I am not carrying, my lord. My lord, I have to place, my lord, before your lordship, if lordship
Monday, there are none. For your satisfaction, I am keeping it on Monday, but there are none. No judgment on that one. He's a junior member of the bar. Let him come back.
No, absolutely. We all love those judgments already
the petitioner assails an appellate order passed under appellate order dated November 29, 2024, passed under section 107 of the WBGST Act, 2017. Full stop. Learned advocate, your name is Mr. Mojumdar?
Yes, ma'am.
He's doing well. Mr. Mojumdar, learned advocate, appearing for the petitioner, submits that the order suffers from serious jurisdictional errors. Full stop. He seeks some time to place on record judgments in support of his contention. Full stop. In view thereof, list this matter on Monday.
Monday, ma'am.
Monday. Monday. Monday.
Within that, my lord, I am taking instruction if they will consider to exchange of affidavits, it will be there.
Then 10%.
No, 10% they have paid, my lord, already.
No. Because
Another 10%.
Second appeal.
Second appeal.
Before the tribunal.
He has got lot of honor.
My lord. Obliged, ma'am.
Lordship, I'm led by Mr. Alok Kumar Ghosh. Lordship, this is a GST matter when an order under section 73 has been passed. Thereafter, we have preferred appeal and the appeal has been passed on the same light. Lordship may come to page number 95 of the adjudication order. running page number 95.
Yes.
Lordship, primarily the case is disallowance of ITC on the ground of exempted supplies. These exempted supplies were originally, one part was my export, claim of export. Another part was services provided to NKDA, which is a government authority, which involved no materials, my lord. Lordship, in the discrepancy number 4, the proper officer have written exempted nil rated and non-GST supply for rupees 24 lakhs 85,662.
Page?
Running page number 95.
Yes. Page 95?
95.
95, yes.
In the discrepancy number 4.
Yes.
There is an exempted nil rated and non-GST supply.
ITC found reversible,
Reversible.
proportional to exempt supply.
Absolutely, my lord.
Yes. Then where?
In the column number, in the tab, in the table, in item number 2.
Item 2, exempted nil rated.
Yes, that is for 24 lakhs 85,662, lordship.
Yes.
That was, if in the next table it is clearly shown that it was firstly our claim of export for 17 lakh 75,000 and 2 supplies of service made to NKDA totaling to 7 lakhs 10,662 in the next table, my lord.
Yes.
That has come to this 24 lakhs 85,662. Now, lordship, apparent mistake is there. In the previous table, in the column number 3, this 7 lakh 10,000 has been added twice upon that 24 lakhs. That 24 lakhs includes this 7 lakh. That is apparent from the next table.
Now, how do you say that? The next table which you are showing,
yes, lordship,
is an extract from your reply.
Absolutely, lordship. That has been taken from the GSTR 9 that we have filed.
So this is your calculation. So
Yes.
how do you say there is double calculation? That is the calculation that you have given to the authorities.
Yes, that is an explanation. So I'm not saying that it is wrongly added doubly. It's my contention. No, the authority have wrongly added it again.
That is what I am unable to understand. This is your extract. So how have the authorities added this?
Lordship, in the previous table, that is the authorities table.
Yes, there it
They
is
have
only
added
one.
firstly the 24 lakhs. 24 lakhs they have stated.
Because this 24 lakhs comes from this.
This only, lordship. That is my contention, lordship.
Okay, yes.
So
and then 7 lakh 10,000 is again mentioned.
Again it has been added and total had come to this 31 lakhs.
Includes the 7 lakhs.
7 lakhs twice. This is the first thing, lordship. The second thing is, lordship, they have stated that in the appellate order, if lordship will come to page number 117. 118, lordship.
118.
Yes, lordship.
Yes.
Lordship, in the 4.3 last 2 paragraphs, the appellate authority is saying that the shipment has come from Goa to Calcutta and then it was finally made to go to Nepal. As the fate of the goods supplied by Siemens is not been established. Lordship.
Where is that? Where have you?
Lordship, in the point number 4.3.
Yes.
The second last paragraph.
Goa to Kolkata has been established. Yes. Where do you find Nepal?
Yes.
Where?
Lordship, if my lords will come to page number 73, my lords. Running page number 73.
Yes.
Lordship, this is a certificate issued by the Indian Chamber of Commerce against this export, whereas it has been stated this material, particular material, against the bill number detail showing in the below part of the page, supplied by this supplier, has traveled final destination is Birganj, Nepal. On the top left part, my lord.
Final destination.
It's Birganj, Nepal. Moreover, my lord,
No, so what has the authority said about this?
they have construed it as exempted supplies and reversed my proportional ITC. If they had accepted it as export, I am very much eligible for this ITC. They have not accepted this as export. They have only made it out as an exempted supply, not as export.
And what is the law on this?
Lordship, in case we have exported certain goods under LUT, we are very much eligible for the ITC against the same. Moreover, Lordship, this is a document from the Indian Customs showing that the same has crossed the border to Nepal.
This is not a part of the writ petition.
I'm afraid, my lord, it's not. That time we didn't have this document, Lordship, at the time of filing. Now, Lord.
Difficult to read also.
Actually, Lordship, this was printed in, I think, a dot matrix printer. So that's why the print quality is not very good, Lordship.
No, not very good, very bad.
Absolutely, Lordship. I'm very sorry for that. Lordship, now if I come to the second part of thing, the supply of service to NKDA.
So you have 2 points as of now.
Yes.
One is the inclusion of the 7 lakh component twice.
Yeah, absolutely, Lordship.
The second is treating your exported goods
As exempted supplies and disallowing proportionate claim of ITC on that. Now, Lordship, on the third point, supplies of service made to NKDA. Lordship, NKDA is a government authority well covered under 243G of the Constitution. That is well covered. Now, Lordship, sorry, 243W, my lord. Sorry. Lordship, in running page number 47, Lordship, there is the invoice of these supplies of services.
Page
47 and 48, Lordship. And Lordship, in page number 84 and 85 are the work orders for these supplies of services.
Just a minute.
Absolutely, ma'am.
Yes, 46 or 47?
47 and 48, my lords.
47.
47 and 48. There are two invoices
All
provided
these
to the.
documents were there before the appellate authority.
Absolutely, my lord. Absolutely.
They have considered these documents.
Yes, yes. In the appeal order itself, they have mentioned these bill numbers, my lord. In page number 117, this the bill numbers with values are categorically mentioned in the appeal order, my lord.
Yes.
Lordship, if again, if my lord will come to page number 84 and 85, and that is the work order given to the petitioner from the NKDA.
Yes.
Lordship, firstly, I'll take my lord to page number 85. The subject matter written acceptance come work order for energize the panel against meter number such and such from such and such solar plant near so and so place. In the subject column, my lord, 85. Lordship, according to my understanding, what my client have told, this energize the panel is just plugging in a complex machinery which works on solar, and to make sure it is working fine. To the authority, they have to show that this panel is working fine on the solar grid. So, Lordship, on the very face of it, it is understandable there is no material involved in this. It's just labor job.
May not be. That is very factual. Very factual. How has the appellate authority dealt with that?
Appellate authority in page number 118, my lord, on the top paragraph, 4.2 end paragraph, Lordship. (118), my lord, top part.
But you have failed to produce evidences. That is what they record.
Lordship, they have asked for the particular goods which were procured to execute that service. We have not procured any goods, Lordship. How can we produce such documents? Our contention is it's pure labor. There is no question of any goods involved on these two work orders.
Yes, Mr. Chakravarti.
W. 243 W. Oh no. Acha, petition at W.
When do you want to come back?
First of all, he has said there is a double.
There is a double. He has 4 points. One is inclusion of 7 lakh and odd amount doubly. Second is that goods cross the borders of India, reach Nepal. But the authority at page 118 has said that there is nothing on record to show. Now, why did you not accept this page 73 as good enough? Rule 96. Rule 96. Yes, yes, of course.
This is the provision. There has to be a capital.
This is a person availing option to supply goods or services for export without payment.
That's why they could have funded the same. So I don't know the case of that.
No, refund কোনো কেস নেই, রিফান্ড ক্লেমই নেই।
লিখে নিন।
আইটিসি ক্লেম আছে, সেটা রিফান্ড চাই।
This writ petition takes exception to an appellate order dated. What is the date of the order? Appellate order dated what is the date of the order?
Lordship.
March 17, 2025. Yes. March 17, 2025. Passed by the appellate authority under section 107 of the WBGST Act. Full stop. Mr. Heard learned counsel appearing for the petitioner. Full stop. Mr. Chakravarti learned counsel appearing for the state for the WBGST authorities. Seeks time to take appropriate instructions. Full stop. List this matter for further consideration on November 17, 2025.
Lordship, in the meantime, no coercive action, Lordship.
Not now. You will take any coercive action in the meantime.
Lordship, grateful, Lordship.
Affidavit of service.
Grateful, Lordship.
Appeal is under challenge question.
What is wrong with the order?
Fact is that Lordship, I am a supplier of recharge voucher of mobile phones, and two big service providers, Tata Docomo and Aircel, vanished from the market, and they did not disclose the sale to me in the GST R1. That is why mismatch was apparent in the face of the records.
The order is dated 12th of September 2024.
Yes.
Why so late?
In filing the writ petitioners.
What is wrong with the order? Pay 10%.
Yes.
The petitioner assails an order dated September 20. What was the date? September 12, 2024, passed by the appellate authority under section 107 of the WBGST Act, 2017. Thereby, adjudication order was confirmed or modified?
Confirmed.
Thereby confirming the adjudication order dated
19th May 2023. 19th May 2023.
May 19, 2023. 2023. Full stop. It is submitted by the petitioner that although the order impugned herein is appealable, yet since the appellate tribunal has not yet become functional, the petitioner has no avenue to assail the order impugned. Full stop. Hence the writ petition. Full stop. In view of the fact that the petitioner has no remedy elsewhere, this writ petition is entertained. Full stop. If the petitioner deposits a sum equal to 10% of the remaining amount of tax in dispute arising from the adjudication order dated May 12, 2023. With the WBGST authorities, comma, in terms of section 107 within bracket 6 within bracket B of the WBGST Act, 2017, and furnishes proof of payment thereof to the WBGST authorities, the WBGST authorities shall not take any coercive steps against the petitioner till disposal of the writ petition. Full stop. Mr. Chakraborty, learned advocate, appearing Mr. Chakraborty, learned advocate, appearing for the WBGST authority, seeks time to file an affidavit in opposition. Full stop. Let such affidavit in opposition be filed within 4 weeks from date. Affidavit in reply thereto, if any, be filed within 2 weeks thereafter. List the matter for hearing immediately after expiry of the time fixed for exchange of affidavits. এরপরে ওইটা লিখবেন স্টের ব্যাপারটা।
certain time period
না, এটা লিখে দিন যেখানে লিখেছি deposits within a fortnight.
No, sir, amount is used, that is 3 crore rupees. I seek certain time, 2 or 8 weeks or so. I have to deposit 33 lakh.
The coercion will stop after payment. That is the problem. There is no unconditional order.
That liberty.
So they are not making time. Whenever they pay, the coercion will stop.
It's already 1 year.
Kindly allow 8 weeks time. 8 weeks time. 33 lakh rupees has to be deposited.
And I'll have to stay it unconditionally for 8 weeks.
If I don't deposit within 8 weeks, that order will operate.
8 weeks will be too long time.
My instruction is that 8 weeks time will be sufficient for arranging the amount. And actually, it is no fault on my part.
Difficult. Then I'll have to go into the merits and grant stay.
Kindly allow 6 weeks. 6 weeks time.
And you have approached also after almost 1 year. So
filed on
almost 1 year. 26th of August 2025, 12 September order. Difficult.
Kindly consider such. If the amount is huge, otherwise I would not request you.
That I understand. Then you should have been more expeditious. You should have been more fast. Difficult. Unconditional stay for if that is difficult.
Kindly consider.
Then show me your prima facie case.
Amount is huge, that is why. Otherwise, I would not request you.
Show me your prima facie case for unconditional stay. What is the prima facie case?
Then there is no fault on my part, Lord.
This supplier was Tata, that is it's not actually on very of something. Yes,
that is no fault liability upon. That is 4 weeks.
Within 4 weeks.
Basically, Lord, there is no fault on my part. I paid tax, I purchased.
তার আগে লিখে দিন। ঠিক আছে, if he submits. I'm not granting, I'm not saying any unconditional stay. I'm saying that if you deposit within 4 weeks, they will not take any coercive action. So that should suffice for them.
Then let the matter appear after weeks. The 4 weeks is given for it appear after weeks.
I have said immediately after expiry of the time.
4 weeks and 6.
It will appear as a hearing matter. Affidavit of service filed today. So there is no unconditional stay. Within 4 weeks you deposit, you will get the stay.
That is sufficient.
Lordship, I am for the petitioner, Lordship. Lordship, this is a, I have come up against the appellate order, Your Lordships. Not this point. The points include disallowance of ITC on two basic grounds. One is differences between my claim as per GSTR 3B and what has been auto-populated in GSTR 2A. That is a minor amount of 3 lakhs. And the major amount of 69 lakhs pertains to one purchases from one supplier who is allegedly found to be non-existent at its registered place of business. So that is the point of challenge. Your Lordship may kindly grant us stay since the tribunal is not there. Your Lordship, it is not functioning. Lordships may kindly.
There's been some recovery.
Your Lordships, there have been recovery, and Your Lordships, the recovery is more than the 10%. Your Lordships.
Recovery has already started.
Yes, Your Lordships, it has started, and it has been a substantial amount has been recovered. Your Lordships, the amount is around 77 lakhs from the electronic credit ledger. Lordships, I have attached the credit ledger as well. Lordships may kindly come to page number 68 and 69. Page number 69 is the communication of recovery, and page number 68 is the debit entry from the credit ledger. Your Lordships, may at page 68, the serial number 1. The description, amount recovered against demand, 40 lakhs from the CGST and 36 lakhs from the SGST.
And the demand was for?
The demand is total for 1 crore 42.
As against this, 77 lakh has already been recovered.
Yes, Your Lordships.
So, Mr. Then it should be stayed. Further recovery should be stayed.
So can you record to more than 10%?
More than 10%, Your Lordships.
This writ petition takes exception to an order dated February 18, 2022, an order dated February 18, 2025, passed by the Appellate Authority under Section 107 of the WBGST Act, thereby confirming or modifying?
Lordships, confirming.
Confirming the adjudication order dated. What is the adjudication order's date?
Lordships, 18th of April 2023.
April 18, 2023.
Page 35.
Full stop. It is submitted by the petitioner that the order suffers from several material illegalities, irregularities, and illegalities. Full stop. It is submitted that although the order under challenge in this writ petition is appealable, yet since the appellate tribunal has not yet become functional, the petitioner has no avenue to challenge the order impugned herein. Full stop. It is submitted by the parties. Mr. Chakraborty, you also agree that there has been recovery. It is submitted by the parties that more than 10%, that amount in excess of 10% of the demand has already been recovered in recovery proceedings. Full stop. In such view of the matter, full stop, the attention of this court is drawn to the document at page 68 and 69.
Yes, Your Lordship. 69 is the communication.
At pages 68 and 69 of the writ petition in support of such submission. So this takes care of.
Yes. If you find the reference number, so that matches.
Yes. Full stop. In such view of the matter, the writ petition is admitted, and the respondent GST authorities are directed not to take any further coercive action against the petitioner on the strength of the aforesaid adjudication order dated what was the date?
18th of April 2023.
2023, which was confirmed by the order impugned in the present writ petition. Full stop. Paragraph. As prayed for, comma, let affidavit in opposition be filed within 4 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. List this matter for hearing immediately after expiry of the time fixed for exchange of affidavit. Affidavit of service filed.
Lordship, the next matter is a very small matter, Your Lordships.
I have division bench at 2, so it's always one.
Your Lordships. It gets tomorrow, Lordships.
Next day.